Hi, I'm Jim Covington. Today is April 6, 2017. I'd like to welcome you to this week's issue of ISBA State House Review. There's about 7 bills I want to talk to you about. The General Assembly is about ready to start a 2-week Easter, Passover, spring break starting tomorrow afternoon. A lot of the bills have fallen off by the wayside, not meeting time deadlines that the General Assembly sets for itself, so we've got a more finite view of what's out there. The first bill I'd like to talk to you about is amends the Nursing Home Act. It's Senate Bill 1208, introduced by Senator William Brady of Bloomington, and it amends the Nursing Home Act on the attorney fee award section for a successful resident in action against the nursing home. If non-monetary relief, undefined, is sought under this section, then the licensee shall also pay costs and attorney's fees to the facility resident whose rights in Part 1 of Article 2 of this Act are violated. If monetary relief is sought under that section, then those costs and attorney's fees are not recoverable by the facility resident, even though the facility resident is successful. A companion bill is House Bill 1953, introduced by Representative Tom Dimmer of Dixon. The next bill creates the Collaborative Process Act for family law issues only. It's Senate Bill 67, introduced by Senator Mike Hastings of Frankfort, and House sponsor is Kelly Burke from Oak Lawn. This allows family law matters to be handled in a what I would call an alternative dispute format. It has passed the House and is in the Senate. About 16 other states have adopted this. It's a situation where the parties agree that if the collaborative process is unsuccessful, then the attorneys that are representing them separately in that process may not represent them in subsequent litigation. The next bill amends the child support statutes and the Marriage and Dissolution Act. It's Senate Bill 69, sponsored by Senator Mike Hastings of Frankfort, and it makes a number of technical corrections to the Income Shares Act that's already law, that's going into effect on July 1 of this year. For example, child support award becomes child support or child support obligation, depending on the context. There were a lot of technical corrections that this bill had to make to sort of integrate itself with the Paternity Act and the Marriage and Dissolution of Marriage Act. It does make one substantive change to provide that the parties must take into consideration the federal income tax credit for child care when allocating the cost of child care between the parents. It has passed the Senate and is in the House. The next bill is amends the Code of Civil Procedure on the objections to jurisdiction section 301. It's House Bill 188, introduced by Representative Andre Thapetti of Chicago. It provides that if an objecting party files a motion under section 2-1301E or a petition under 2-14 or 214.01 before filing a motion in compliance with section 2301A, the party waives all objections to the court's jurisdiction over the party's person. This bill is kind of in flux right now, and it is in so it's going to change. It's now in the House Judiciary Committee. The next bill appears not to be moving, but it was a bill receiving a lot of attention, and I'm not sure why it's not moving. There's a lot of reasons for why a bill doesn't move. It basically makes a reporting of child abuse or neglect. It makes everybody a reporter. It's called the universal way of looking at this, instead of a set list of people who are required to list under the Act. And it's House Bill 3288, introduced by Representative Kelly Cassidy of Chicago. It does leave the current exemptions for professionals such as a lawyer with a client under the attorney-client privilege. But 18 other states have this, and there was a lot of discussion what's the best public policy, whether it should be a list of mandated reporters or everybody. And so I just want to give you an update on that. The next bill is an omnibus condo bill, and by omnibus I mean there's just the Judiciary Committee has taken about 11 different pending bills amending the Condominium Property Act or that Common Interest Community Association Act, and they kind of cherry-picked out of them what they thought might be the best of those and put them in one bill, and that's House Bill 189. It's introduced by Representative Andre Thapetti of Chicago. It is still in the House Judiciary Committee. The next and final bill also amends the Condominium Property Act. It's House Bill 3755, and it's introduced by Representative Scott Drury of Highwood, and it provides that in any litigation or arbitration between a unit owner or his or her association or board of managers, or any individual member of the association or its board of managers, if the unit owner is deemed by the court or arbitrator to be the substantial prevailing party, then the court or the arbitrator shall award to the unit owner from the non-prevailing party reasonable attorney's fees and costs incurred by the unit owner in the litigation or arbitration. It further provides that certain attorney's fees shall be excluded from the demand given under the, I think that's 9-106, I believe it is, of the Code of Civil Procedure, and it is still in House Judiciary Committee. Thank you for listening, and we'll see you later.